Ladies and gentlemen of Bachelor Nation, we have breaking news to get into regarding the Clayton Echard paternity scandal, and we are going live for this news right now. Ladies and gentlemen, it's Dave Neal, stand-up comic, host of Bachelor Nation News, and quickly becoming host of the Clayton Echard News channel. A week that was supposed to involve no new information has led to information that Clayton's accuser, Jane Doe's attorney, has withdrawn. And now there's a bombshell 33-page motion to compel. As I was getting ready to make this WTF is this video, what could the motion to compel possibly be about? Well, now we know. I'm going to be getting into this heavily, sharing all of the information with everybody out here, and it already looks like it is pretty wild. In this motion, it involves Clayton's attorneys, Woodnick Law, demanding evidence be provided. And it's kind of heavy. I mean, it's gonna be heavy stuff we talk about. There are supposed to be possible images of what went down. None of which will be shown here because there are none. There are none. But I guess they're saying show us the images of what you claim went down, or else it's BS. And which of course most people know it is. But now we get to watch truth really play out. Now we get to watch the moment where all of the lies are now made accountable. There's that F around and find out acronym, right? FAFO, right? F around, find out. And now we're in the finding out stage, as some of my audience have previously showed. Now, do me a favor. Follow me on Instagram at DNeals for all other updates. Yesterday evening, we actually broke the other story on Instagram because I was away from my YouTube. So if there are last-minute updates that I can get to you that I can't get to here, that's where you're going to want to go. In all fairness, I'm about to share with you guys probably a nice 30-plus minute live stream of everything that is included in this motion to compel. Again, it's 33 pages. It's pretty juicy. I've just started to go through it. After that, we will go live on Patreon immediately afterwards, and the private members will get an additional chance to talk about everything here. This evening, this afternoon, I will be doing my Bachelor Rush Hour podcast. If you cannot pay for the Patreon, that's fine. I've got more free content for you. Free content is king here on the channel, and we've got it all day long. Just do me a solid. If you like what I do, vote with your subscribe button and join the Patreon. Anyone who has a cell phone, join the podcast. Anyone with a cell phone can join. We appreciate all the support. I mean, it's a busy time. I got paint on my hands. I've been painting the nursery, getting ready for very good times with my family. But, the business must continue. And we are about to share that. I'm just waiting, another minute or two as people slowly trickle in. And yes, it is bombshell news that Jane Doe's attorney filed a motion to leave, to be dismissed. But it's like at the dinner table, Mom, may I be dismissed? I want to go play with my friends. No, Johnny, you didn't finish eating your peas. Will the judge say, no, Corey, you didn't finish, trying to protect your client here? Or will the judge let him dismiss? This is what we have to see. Hey, shout out to everyone in the chat. I will be taking any questions. We've got Sarah. We've got all the moderators. I'm sure Bruce is in there, Angel. So Maura says, first time catching a live, watching from Nova Scotia, one of my favorite areas of Canada. You crazy accents, you. I'm from Rhode Island. I'm like if you got lost trying to go to Nova Scotia and ended up in a place where you don't have free healthcare. All right, so let's jump into it, folks. Let's jump into it. We have, like I said, a 33-page document right here, and we're going to go through it. Ruth is checking in from the UK. Have they found Kate Middleton yet? Where the F is Kate? And hello, Toronto. Everyone, let me know where you're from. Houston's in the house. Okay. By the way, again, if you're in the Phoenix area and you're new to me, I've got a great bombshell breaking news stand-up show March 28th that you're going to need to come to. Anyone who's got an aunt or a relative in the area, vote with your dollar. If you want to see more of touring stand-up comedy, then go check that out. March 28th, 2 weeks from today, Clayton Echard will be doing a live Q&A with me. God knows what we'll be able to talk about, but he'll be there, I'll be there, and we'll be hanging out. You're not going to want to miss that show. April 14th, also a show in Nashville. More on that soon. All right, let's get into it. Again, some of this might be redundant. We've got the extortion attempt, but as I've got there on the main, let me see if I can find out where it was. As I had there in the main photo, compulsive lying is not a defense to disclosure. So that's what this motion seems to be about, right? Is I want a motion in the ocean of the Clayton Echard paternity scandal, a motion to try to get some discovery out there. What is a motion to compel? Real quickly.
In this video, we will discuss...
Boring! So, we don't have the time. So a motion to compel, as far as I know, and the lawyers out there could let me know, is saying, all right, compel her to share this evidence she still says she has. Hey, Maha, checking in from Denmark. Good to see you. And we got Denmark to Texas to Denver, Colorado. Having the babies if you don't come to my stand-up show, March 28th. Okay, here it is. Respondent Clayton Echard, buy-in through counsel, undersigned in pursuant to Arizona Rules of Family Law Procedure, hereby moves this court to compel petitioner's disclosure and enter appropriate sanctions for her non-compliance. Essentially, in my eyes, and please let me know if I'm wrong here, not a lawyer. I just did background work on The Good Wife back in the day. See if you can find that out. Yeah, that's right. Find me on Law & Order. The closest to a courtroom I ever saw was in a production studio, but here we are. I did not make it to the courtroom February 8th when I was sued for harassment by Jane Doe. She dropped those charges moments before she was set to face me in court. She did not want to commute to LA. Neither did I, although I would have loved to go to Millie's, my favorite diner. That would have been a fantastic reason to be there. If you ever live in LA, you got to go to Millie's. All right. Or Pergoletta if you want to go to Italian food for dinner, but I digress. At petitioner's Rule 57 deposition on March 1st, 2024, petitioner testified she altered an ultrasound image, falsely claiming they came from Southwest Medical Imaging. She miscarried 2. And again, guys, gonna be kind of heavy stuff here, but that's what this court case is. The heavier the content is in this docket, in this court packet here, the heavier the misuse and mistrust of humanity, which they allege, was, committed by Jane Doe, right? Sarah said, can you make the document bigger? I'll make it as big as you want. You want that? Is that good? Can we do that? Is that okay? Let's do this here. I will make it there. In fact, I can actually go to my Patreon. Now let's go back here. We'll stay here. Let's stay here on this one. So how's that for you guys? You can follow along. Oh, hold on. We're in the live, folks. 700 people in the chat. If you are saying, Dave, we want this court case to get out to a bigger audience, hit the like button and leave a comment and subscribe. That tells YouTube that this is a fire channel right now, and they will promote it to new people. Let's get involved in LawTube. Let's get involved with people that can make documentaries and get this case out there. Wouldn't it be great? Wouldn't it be nice if we lived in a country where we can change the laws so it never gets this far? Bruce says things are happening. Indeed. Bruce, we got to talk after this about that hotel. I don't want to say it on air, but I definitely need to book that. I need to remind myself to book that. March 27th, I get into town. Maybe we can go to a steakhouse or something for dinner. Wouldn't that be fun? At petitioner's Rule 57, okay, so she miscarried 2 hand-sized fetuses sometime in September or October and was seen by yet to be named telehealth providers, but provided no records regarding the same, nor confirmation of the date of the alleged event. So again, these are in her terms. What Woodnick Law knows is that none of this actually happened. Now, if you're wondering about the SMIL, excuse me, the SMIL imaging company, I think they go by Smile. I'm going to just share. I know I've shared this before, but we have a lot of new people here. I'm going to share with you guys the actual ultrasound that is being referenced here. So this ultrasound is right here. Proof it is fake. 78,000 people have watched this video. Here it is. That's the ultrasound right there, right? And I scroll it together and overlap it. Baby B on the bottom, placenta. That's the real one on the bottom. So if you see it, again, one more time, I'm showing you the areas of fraud that I guess she doesn't believe this is fraud, right? So down at the bottom here, see what I'm the image. This right here, September 5th, 2023. This is, I guess, hers. I guess this is what she put on there, right? And on the left, I've blurred out her name. But as it goes further, we see now right there, SMIL. That's a company that exists. And that company didn't find her babies because this ultrasound is 7 years old. Well, this one is the one she made up. This one right here is a 6-year-old ultrasound. So what I did was I overlaid the one she wanted us to believe was hers on top of the one that is 6 years old. I cut to the parts. So what happened a few years ago is Greg Gillespie alleged that she faked an ultrasound and they used reverse image searching. So you can look at a photo and then you can put it into Google and Google can say, oh yeah, this photo existed on a blog years ago. And then that's how you can catch someone. So my guess is she's trying to adapt in the wild and she's like, you know what? I'm going to include a video this time, but I'm going to take the 4-minute long original video, cut it down into 90 seconds, and that way they won't be able to search it. Well, little did she know, Bachelor Nation must have some free time on our hands. So much so, we should find Kate Middleton. I mean, we got all this time. Can we find the royal princess or whatever? So either way, I'm not a big royal family person. I'm all about, we left for a reason. We're the jaded exes. We don't want you. We'll do it ourselves. We'll have our own dumpster fire. So either way, she edits that out. People find the original. I don't know how. You guys are fantastic. I overlap them at 50% opacity, which means I overlap them in a way you can see both them moving at the same time. I edit it down to the exact frame of the heartbeats of these actual real babies, which must be a boy and a girl that are 6 years old now. We should meet them. Hey, did you know that your first images were hijacked by a scam paternity case? Either way, oh, there it is. And of course, we included the music here just for effect where it all comes together.
Andrew, you are not the father.
Hey! Whoa, 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 oh, oh, hey. And then Clayton dances, does his nasty. Hey, what? And so he knew he wasn't the father. I mean, he knew this, but now it's about proving it in court. So she doesn't get to write, fan fiction about her, about him, about me, about all of these things, right? All right, so that catches you up. That's what they're talking about when they talk about the image that was from Southwest Medical Imaging. So we're going to get emails. We're going to see that right now. We're going to see the emails where apparently we find out things didn't exist. So she miscarried them, and when she miscarried, she took photos of what would have been 19 to 24-week twin fetuses, which, by the way, this is all interesting stuff. Breaking news. There are alleged photos. Now, again, guys, because our audience is so amazing and heartwarming and so many people have wanted to share their stories, we've had people share us their evidence of actual miscarriage, of actual stillbirth, of death certificates with the little baby foot and all of the. Again, I know it's shocking to hear this, but it's important to illustrate the emotion behind what's actually going on here. Anyone can read these documents, but if I can do anything for you, it is illustrate the emotion of how freaking ridiculous and offensive this is. Having witnessed and had real people with real stories of loss come forward, having been in my own birthing classes with a bunch of other, amazing people who have talked about their struggles, having had people come to me after stand-up shows and say, in tears, hey, I struggled for a long time to get pregnant, so what you're doing and what you're talking about is a big deal. And then them sharing with me the good news that they're now pregnant and all of that. I mean, children have been birthed and children have been consummated, whatever they say, during the long trial that we've had here. But the children that do not exist, as far as any evidence has proven so far, are the children she claims she lost at 19 to 24 weeks. She no longer had the photos, which she claimed she sent to her sister. Get her in here. Get the sister in here. Let's do it. Get her on the phone. Let's go. She just invited, and again, can I get a lawyer to call in or something? By the way, if anyone in the chat is a lawyer and can speak to this, in this motion, we revealed that in the deposition, she mentions her sister, who we'll call, what's another name for Jane Doe? Jill Doe. We're going to call the sister Jill Doe, okay? So she says she sent them to Jill Doe. Can we subpoena the companies? I mean, this is data. This data does not go away. Well, it turns out that Jane Doe got a new phone, she says, and there is a fourth case in California where someone alleged that, whoa. Ladies and gentlemen of the chat room community, breaking news. A new victim emerges. There is a fourth case in California where someone alleged that petitioner Janie Dodo Bird III fabricated a pregnancy. When does it end? Now, Jane Doe's 33. Can she do this for 15 more years? I mean, until she hits menopause, men are at risk here. Linda said her sister cannot be happy. I'll tell you what. That's right, Damiana. Another one. Her sister has not spoken. And look, her sister may be a victim of hers, for all we know. Her sister, she might have family secrets the sister does not want out there. We've all got family members that we're just like, okay, I don't want to, we all know something about each other. What could it be? What could it be? It could be that her sister, who had a baby, is living a happy life on the other side of the country. Absolutely. That could be the case. That could absolutely be the case. I know that people have reached out to the sister. I haven't personally. I haven't reached out, but she doesn't want to talk about this. And apparently the first victim here in California, I guess they're calling it the fourth case, which probably is the first case if Clayton's the fourth. We have to shuffle this all around, but this goes to show people don't want to deal with her. They've moved on. They've had their own families. McNutt says, holy cats, this is insane. Absolutely is insane. We're seeing who's coming in here. Lots of comments coming in. Again, keep hitting the like button. Not to say that we like this heavy topic, but just to get the word out to as many people as possible. We have over 1,000 people in the chat right now. Compulsive lying is not a defense to disclosure production. Get out of here! Oh no! Oh my gosh, they're calling her, I'm wearing my gym shorts, guys, because I'm running up and down the court. They're calling her a compulsive liar right now in court documents. So again, we're only on page 2. Here's where we're at. This motion to compel has shown that a fourth alleged person claims she fabricated a pregnancy. Or I should say the person alleged that she fabricated a pregnancy. I also have heard of this person. They have not been introduced to this court case, but we have had sources tell us this person's name, that they exist. We know what they do for a living and all these different things. They live in a world where they don't want their past dealt with because they probably mourned the loss. People probably believe them on their inner circles. And here's my offer. To the person who alleges that she fabricated a pregnancy in California, please come forward. Please come forward. I know you're a strong person. You don't have to be public. You can talk to me anonymously. Give us some more information, if you will. I know your friends and family are listening. We'll handle your case with kid gloves, but we would like to know more with regards to the pattern of abuse that is here. And maybe the laws can get changed. Maybe this can be the Clayton law, the Clayton Echard Amendment. You know what I mean? Hey, maybe we could just call it the Suck My Nuts Law. What if we did that? We could just call it the old Suck My Nuts Law, and we could just, SMN, the Suck My Nuts amendment. Media says, I'm not shocked there's more victims, of course. Bruce says, justiceforclayton.com page for all the wiki magic. Yes, this will be updated, I'm sure, very soon and put on the justiceforclayton.com page. She's had these pages taken down, and she had the Sun article taken down where they alleged she fabricated documents. And it's like when she goes, I didn't fabricate documents, you put a different image and a different title card, and you put your name on ultrasounds that weren't yours. That is at its basis fraud behavior. To be Flair says, yes, Dave, records can be subpoenaed and the sister can be subpoenaed, even if only through written questions and answers, as she has been identified as a person with knowledge. There you go. Cindy says, how funny. SMN for Suck My Nuts, aka Semen, SMN. Yes, it's Semen Season, SMNSZN Season. Put that on a license plate, why don't you? Let's keep on going. Compulsive lying is not a defense to disclosure production. Petitioners increasingly apocryphal tales. Why you gotta give me hard words? I went to public school. Petitioners increasingly apocryphal tales include her telling Us Weekly just last week that her pregnancy was confirmed at an urgent care. Again, HCG tests are not confirmation of pregnancy. While the loss of a pregnancy is a tragedy, the loss of a fake pregnancy is not. Wow, how interesting. And of course, she's hidden behind these words saying, my privileged medical records. Well, how funny is it when the judge says, don't share her medical records? Well, it turns out what is being shared is her lack of medical records. How wild a story. Who knew Thirsty Thursday would deliver so much? Well, the loss, I need a Diet Coke. Can somebody get me a Diet Coke in here? We're partying. Sad party. While the loss of a pregnancy is a tragedy, the loss of a fake pregnancy is not. Here, petitioner Janie Dodo Bird III was photographed competing in horse jumping competitions with a flat stomach, weeks before she appeared in court, before Judge Gail Ketkis, with a seemingly large pregnancy stomach, moon belly, claiming she was 100% and 24 weeks pregnant by Clayton, who she never had sexual intercourse with. Why did she say she was pregnant? Well, I'll let Greg Woodnick explain.
She lied?
She lied. I mean, that's the only scenario, is that.
She lied?
Oh, Cat Lady Ballerina says, I have a Fountain Coke Zero. A Fountain Coke Zero is the best kind. Don't come and tell me you got the crushed ice. Can somebody Postmates me a Coke Zero, please? Notably, of the litany provider names given through 14 plus, that's my lucky number, given through petitioner's testimony prior to her deposition, multiple providers have denied providing care or even communicating with petitioner. Moreover, petitioner lied about obtaining obstetric care because sonograms taken by actual sonographers cannot be easily faked, nor can fetal anatomy scans or the frequent checkup appointments one would expect to have for her proclaimed high-risk twin pregnancy. By the way, not to make this about a real pregnancy, but we went to the hospital last night and saw where we're going to be giving birth. It's a birthing center, which is amazing. Because it's got all the professional doctors and nurses, but you can bring your own doula. BYD, bring your own doula. You can do that. They've got balls you can sit on and poles you can hold on and whole different contraptions you can do, stirrups you can, all these. They've got a diffuser so you can bring your own scent. Let me ask the comment section, what is the best scent that I can bring to deliver a baby boy into this world? I am going to be, we're in delivery when you get a canned Bachelor Rush Hour episode. It'll be like, hello, it's Dave Neal, and it is May 2nd. 2024. It's going to be like AI generated. But either way, we're very much looking forward to that. We'll have information up on our vlog channel regarding the thoughts of what to bring as far as what sweets and treats, and don't bring too many salty foods, and energy don't bring electrolytes. Like all of these things, we're so excited. The lights are dimmable. The last thing we wanted is to, you know me, I care a lot about lighting. The last thing I want to do is bring a baby into this earth with too much UV lights. You know what I mean? It's like, all right, let's put the lights down low. Maybe we'll play some Janis Joplin. Jen says a woodsy scent. Betsy says lavender. Lots of lavender, vanilla, lemongrass. Oh, the ladies. Jane says fresh cut grass. Very much lavender is great for childbirth. Okay, either way, let's go back to this story. Just wanted to share that on today's Bachelor Rush Hour podcast, I actually included a little bit of information about how excited we are. We were in the orientation. I'm crying for no reason. We're going over non-emotional things, and I'm just like, oh my gosh, it's happening. All right, anyway, let's get back into it. All right, so we are going to show you exhibitions. We have a lot here. She denied, we're going to see the exhibits, excuse me. We're going to see the exhibits of the medical providers denying they ever provided care to her. Not just to her, but maybe an alias, a name that she goes by. Oh boy, how do we get over here? Let's go back to this one. That's where I am. Okay, so anyhow, folks, again, 1,167 people in the chat. So if you're new here, hit the subscribe button. Let us know where you're from. And the story's not going anywhere. There's a lot of new information coming out regarding this deposition that we're getting through. Undersigned counsel has, excuse me. I was on the wrong page here. Hold on, we're going live. There it is. Undersigned counsel has sent petitioners current counsel reminders that this data needs to be immediately disclosed per Rule 49. Again, current counsel was Corey Keith. Current counsel was Corey Keith. And Bruce said, seems like it was filed before the motion. Yes. So at this time, they didn't know she was not only without babies, but without lawyers. What has she lost more of? Fake babies or lawyers? Maybe they're all on that asteroid together. They all got abducted. Counsel has not only received no response, but no response to efforts to meet and discuss consistent with Rule 9C. Nevertheless, Rule 9C has been complied with. So what Greg Woodnick is saying is they're not even responding to us. What he probably didn't know at the time was that's because Corey Keith had one foot out the door. Hey, Angel Victoria with a $20 super chat. Oh my gosh, Angel, come on. 20 Coke Zero Fund. Oh, that's funny. Thank you so much. Media Content says, I'm in San Francisco, Jane Doe's hometown. Yeah, very nice. Very nice indeed. Okay, yes, they need a Lifetime movie about Jane Doe. Who will play Jane Doe is the question. Maybe we can get, what's that girl, McSweeney? Who's the girl from Euphoria? Can we get her to play Jane Doe? JD has pictures that the sister disappeared, but JD didn't know she miscarried. Yes, that's the big question. So in November, and again, maybe they'll address this here. In November, we had Jane Doe saying, and again, this came out at the deposition, right? Or this came out in January. She says, well, I didn't realize I miscarried till November when they told me that I actually miscarried 2 months earlier. So why would she have photos of what we're going to see is sadly, gruesomely described? And the fact that she had to look into all of this to get her story straight. Sydney Sweeney, yes, that's who I want. I want Sydney Sweeney to play her. No, we need someone in their 30s. Oh, we kind of need someone who's likable but can be twisted, Maybe, oh man, can we get Margot Robbie? Amber Heard says Chris Jenner. Oh, get out of here. Aubrey Plaza is good. Aubrey Plaza is very good. Okay, anyway. As and for his motion to compel, respondent states as follows. This is what Clayton states. On August 1st, 2023, petitioner initiated the underlying actions. Okay, so let's barrel through this. Where she filed her petition to establish paternity, legal decision-making, parenting time, child support, alleging she was pregnant with respondent's twins. You might know all this already, but it's important to get this timeline hammered down. August 21st, 3 weeks later, respondent filed his answer, denying that petitioner could scientifically be pregnant with his twins after they engaged in oral sex. On September 28th, maybe that was his pickup line. This was I'm going to reenact Clayton's pickup line on May 20th, 2023. All right. Anne Hathaway, says Sarah. Anne Hathaway is an interesting one. Anne Hathaway's, Allison Brie. These are great. Now the question is, would they do a Lifetime movie? I don't know. I will. You can hire me. Who's going to play me? Me. I'm going to play me. Oh, there's Dave Neal just trying to further his acting career. No. Okay, but I will play me. I'll work out a little bit and try to get back to my goal weight. On September 28th, the parties attended an early resolution conference and entered into a Rule 69, that's odd, agreement stating petitioner agrees to contribute a sample on October 2nd to determine paternity of the alleged pregnancy. October 6th, petitioner filed for an order of protection against respondent granted by Judge Duty. They call him Judge Duty because he took a shit all over Clayton's First Amendment rights.
She lied.
Didn't even ask to see his evidence, alleging that she was pregnant by him and that he was cyberbullying her. That's right. Judge Duty did not grant Clayton's evidence, didn't want to see it, just said, no, we're going to hand her. So one more thing Clayton needs to get is he needs to get that order of protection reversed and maybe try to get whatever fees he can from that. October, that's a whole different, that'll probably be in a different case. October 18th, petitioner filed and this is where we're starting to get threats with lawsuits. Lou says it's time Dodo Bird is stopped. Absolutely. October 18th, petitioner filed a request for pre-decree mediation, alleging respondent would not speak to her, and he even acts as if the unborn children don't exist despite a preponderance of evidence. That means preponderance of evidence, I'm assuming. So she filed a request for a pre-decree mediation. They denied her request for mediation. So that's where it gets kind of interesting. I don't know too much about that court date, but the fact that they denied her request for mediation, was it the judge who denied it? I'm assuming, or Clayton. It must be, because I guess Clayton could deny mediation. And this, you can see, is another attempt by her to use the court system to her advantage. Threaten the court system, but don't actually stay in the court. She wants to have the court in her back pocket, but not actually go to court. That's what it seems. Now, that's why it's so important that Clayton got the money raised for him by you guys. Thank yourselves. Pat yourselves on the back. Without that money, Greg Woodnick's company would not have been hired here, and this train would not be heading down the path that it is. October 24th, petitioner appeared on video in a court proceeding before Judge Gil Ketsis wearing what appeared to be a fake pregnant stomach. They call it the moon belly. They always call it the moon belly. I've never heard that before. On November 2nd, 2023, in the second day of trial on respondent's granted injunction against harassment against petitioner, she testified under oath that she was 100% and 24 weeks pregnant by respondent and that she was due on February 14th. And again, this is why it was good that money was raised for the lawyer. They were able to ask her all these questions that are now being used in certain ways to share that that our timeline's completely messed up. So on the November 2nd, in the second day of trial on respondents granted injunctions against harassment against petitioner. So she testified she was 100% pregnant in 24 weeks. So at that point, she would be 24 weeks pregnant. So if she did find out she lost the baby, it would be a stillbirth after that. But of course, she claims she lost it before then, que convenient. That she was due. Petitioner further testified that she was having a high-risk pregnancy due to her alleged epilepsy. And, of course, being pregnant with twins is also high risk. And that she was being seen by Dr. McCool. I'm Dr. McCool and Dr. Higley. And that she had an appointment with Dr. Higley last Friday. Petitioner willfully and wantonly refused to comply with any discovery rules, forcing respondent to file the following. So because she wouldn't share any of this information, he fired a notice of non-appearance at deposition, response objection to petitioner's motion for confidentiality, which again, this was all granted by the judge, and a reply to petitioner's response to motions for sanctions, amended response to petition to establish paternity. It was not until the status conference, and again, we have a lot more to get to, but I don't want to skip over this, guys, so we have a lot more to get to here. Go have a if you understand this part, go have a Diet Coke, go drop me off a Diet Coke, or a Coke Zero, a Cherry Coke Zero, or a Coke, or a Diet Dr. Pepper Zero. Those are pretty good too. I'll take any of those. A vanilla Diet Dr. Pepper Zero. Anyhow, she signed the HIPAA releases in open court with the wrong year. Oh, this is interesting. It was not until the status conference before the court on February 21st that petitioner agreed to sign a basic HIPAA release to allow respondent to obtain the documents himself, and in compliance with Rule 2, which petitioner invoked. Of note, petitioner apparently mistakenly signed the HIPAA release in open court with the wrong year, causing numerous providers to reject the HIPAA release as expired. Oh, she got the year wrong. Oh, it's February, 2023. For all of the, for as smart as she claims to be, and maybe she did this on purpose, I'll let you guys know in the comment section. Do you think she either A, signed Madeline well and says, I'm dying at the wrong year bit. It's not only was it the wrong year, she claimed the dog ate her HIPAA release. Do you think she did this accidentally, which, could have happened? Do you think she did it on purpose, or do you think she drank so much Monster Energy drink that it actually sent her back into the previous year? Did she time travel? Do we live in a new reality where if you drink enough fertility medication, you get HCG positive? Did she time travel with HCG? When you combine HCG with Monster Energy drink, you go back in time 365 days. And at that time, she realized she's no longer... So the reason she hasn't tested positive is because she lives in a different dimension. I will say this. We're doing this live, folks. She does live in a different dimension. What dimension? Whatever wild reality that she thinks she's getting away with this. She lives in the dimension that is not holding her accountable. Sadly, for her, we live in a dimension where justice is rising to the surface. Lou Landry says 100% on purpose. Lucinda, on purpose. Betsy, on purpose. I can't believe they didn't catch this at the time when she signed it. Maybe it's because, I don't know. Maybe she wrote it small. I don't know. Who knows? Maybe the Monster Energy caused her to shake and she meant to draw a 24 and she drew a 23. Since the status conference, respondent Clayton has received confirmation from nearly all providers that petitioner was never a patient of theirs. Well, that doesn't mean they received that from all providers, nearly all providers. By the way, thank you guys so much for these super chats coming in. Luis with a $10 super chat said, Dave, I hope you know how appreciated you are for everything you do. Luis, thank you. That's very, very kind. And I think I missed an earlier super chat we had, but there's so many comments coming in. Corinne Bunderman said, you rock, Dave. Thank you so much. I would like a Diet Coke on the rocks. That's what I would like. I don't think we have any here. I'm going to make do with this cold brew that I have here with a lot of heavy cream. I may shit my pants, but I want you guys to know if I do shit my pants, I'm doing it for you. This is for you. This is a pants shitting worth live stream. I don't shit my pants for less than 1,000 live subscribers. By the way, we're at 1,300 right now. Hit the like button, and please, if you like this content, I implore you to subscribe to my podcast, Bachelor Rush Hour. I keep on shouting it out. It is becoming a major piece of content in my calendar, my daily calendar. And as we keep on getting more subscribers, as we keep growing, I'm looking at hiring a show producer. I'm looking at getting the podcast also on YouTube. I'm looking at revamping and upping it so that it is uber professional, twice daily, morning and afternoon. As soon as we're done here live, I'm going straight to Patreon to continue to talk and make the podcast. You will get a new afternoon rush hour where we discuss this further, and as new information comes out, we'll continue to share it. All right. And again, we have 4 downvotes. So for all those that like what we're doing, keep on hitting the upvote an odd number of times. It was not so then we find out that the HIPAA releases are expired. Since the status conference, respondent has received confirmation from nearly all providers that petitioner Jane Doe was never a patient of theirs. Notably, the HIPAA releases for Dr. McCool revealed that petitioner had never attended an appointment at his office, despite her testimony before Judge Gil Ketsis in the appointment confirmation email that she submitted as evidence in her injunction matter. So she said she had an appointment, she just never went to it. Days prior to petitioner's deposition, petitioner sent respondent's counsel a letter excluding her own attorney, blatantly seeking to extort respondent into dismissing this action, or she would file a baseless, incoherent, and legally unsupported lawsuit for $1.4 million. if respondent agreed to sign a stipulation to dismiss this action and to mutually agree to forbear from any future legal actions, she would not pursue the fake legal claim. So, of course, they called that extortion. You know, the courts can decide, it doesn't reach the level of extortion. If it looks like extortion and smells like extortion, you know what it is. More bizarrely, at the deposition of petitioner on March 1st, petitioner confirmed this, that she had never received obstetric care for her high-risk pregnancy with twins and denied being the owner of the sonograms petitioner posted on Reddit and or provided to various journalists at the beginning of the case. Okay, so give me a second to pull up some information regarding this, but she 100% provided proof that it was her sonogram. She sent it to Reality Steve, and she also, in correspondence with me, said that it was her email. It was only when she realized people were calling it out as a fake email that she actually responded to me and said it wasn't hers. So I have the email she sent me where she said, no, that's not mine. And at that point, we had already confirmed that she had uploaded it into her Dropbox. Again, once we were onto her, I asked her for confirmation. And I said, is this your sonogram? She says, no, that's not mine. She claims Greg Gillespie hacked into her account on multiple occasions. Can she get some two-factor authentication? What we know about Jane Doe, the one thing we can say about her is that she's actually extremely smart when it comes to hiding her footprints digitally. Okay, the babies don't have footprints because they're fake, but she also has hidden her digital footprints. That being, she says, no, that's not mine. Greg Gillespie hacked into it. But what we know is it was in her Dropbox. She sent it to Reality Steve, and she claimed it as hers. She doctored the sonogram to attribute. So anyway, she says it's not hers. She had never received any care. She doctored a sonogram to attribute it to Southwest Medical Imaging and added her name, date of birth, which was previously an exhibit in the court proceedings. What they may share here is not only did she add her name, she put first name first and then last name. She did it wrong. She put Jane Doe instead of Doe Jane. The time code wasn't working. We knew before she put Southwest Medical Imaging on that it was a crock of shit. We knew it was. Any one of these 5 different pieces of evidence would have proven that the ultrasound was not hers. The fact that it already existed 7 years earlier, and unless these babies were frozen for 7 years and came back to life, again, maybe in a weird, maybe something to do. Maybe, again, I don't know. Could it be that the HCG combined with Monster Energy drink created antifreeze, which froze the babies for 7 years? I don't know. She doctored a sonogram to attribute it to Southwest Medical Imaging and added her name. She did this according to her testimony because she had initially gotten the sonogram anonymously at Planned Parenthood. Oh, now we find out. So she admits to doctoring the ultrasound, but she says, I doctored this ultrasound because I had already gotten the ultrasound anonymously at Planned Parenthood. Guys, you can be anonymous to the public, but you can't just anonymously go to medical facilities. And I ain't no expert. Maybe someone in the comment section can let me know. Deb says, the darkest monster timeline. It's the new Monster movie where it's just her fake babies with Monster Energy drinks. It's a blast. You know, they give you a monster out there. Yeah, everyone pees their pants. So, excuse me while I try to wrangle this, folks. You can't go to a medical place and have a procedure, even if it's an ultrasound, anonymously and not have a record of that. The only way she could anonymously get a sonogram, in my opinion, is if she privately hired one of those sonogram delivery companies. I considered doing this for my wife for fun because it was a while since we had a sonogram because we moved, and I was going to say, you know what? There are companies where they'll bring the machine to you just so you can say hi to your baby, which isn't that the sweetest thing in the world? We were going to do that. I was going to do that just to surprise her, but I was like, you know what? We have an appointment next week. We'll save the $400 and, whatever it costs. So that would have been a better excuse, as if she said she privately hired somebody. But Marilyn says you give Planned Parenthood your info. Yeah, imagine Planned Parenthood doing anonymous abortions or, no, that's medical fraud. Absolutely no way. I object. So she says she went anonymously to Mission Viejo Health Center in California, which, by the way, maybe we can call them. Maybe we can call the Mission Viejo Health Center in California. Let's do that right now. Mission Viejo Medical. And again, I wouldn't want to call them, what's it called? Mission Viejo Health Center. I wouldn't want to call them to sort of Mission Viejo. How come I can't even find it? Health Center, Planned Parenthood. Let me see if I can find their phone number here. Planned Parenthood, no, Mission Viejo Health Center. Let's call.
Thank you for calling Planned Parenthood of Orange and San Bernardino counties. For English, please press 1.
Let's do it in English.
If this is a life-threatening emergency, please hang up and dial 911 or go to the nearest emergency room. To make an appointment or for any questions, press 1. For Health Center, would you like to participate in a short customer service survey after your call?
No.
Press 1 for yes. Press 2 for no. Your call may be monitored or recorded for quality assurance purposes. There are 9 callers ahead of you.
Okay.
Many of your questions.
All right. I'm gonna stay on hold. I'm gonna stay on hold with them, and we'll see if we can get to them. All right. I'm on hold, folks. You hear that? All right. I'm gonna turn that hold music down because I don't want to lose my copyright. Bruce says we don't need to call. Okay. He goes, I don't think we need to call. We get the point. She doctored a sonogram to attribute it to Southwest. We know, pretty much for a fact that it's not anonymous. Unsurprisingly, here we go. There we go. Bruce says we don't need it. Bruce, you read ahead of me. Media said your call is very important to us. Well, it's more important to my audience. But again, we don't want to, if there are 9 people on the line for Planned Parenthood, we don't want to clog up the system any more than Jane Doe already has. Unsurprisingly, Planned Parenthood Mission Viejo has confirmed that they do not offer anonymous appointments and they have an easily accessible patient portal. No records from Planned Parenthood Mission Viejo have been disclosed despite repeated requests. According to Jane Doe, the only individual who told her that she was having boy and girl twins was a medical provider to whom she texted a 6-week admittedly altered sonogram. Despite medical science and medical experts stating that a sonogram can only determine the sex of fetuses with accuracy around 18 weeks, petitioner testified that an unnamed provider was able to glean from a 6-week tampering with sonogram that petitioner was pregnant with a boy and a girl. Oh, good. They were able to glean this. I think we found out our baby's sex around 12 weeks, but at that point, I don't think they can do a chromosomal test because there's I don't know. I'm not a doctor. I don't know. But they say here you got to be 18 weeks to do that test. This alleged provider has yet to be disclosed, nor has the text exchange between petitioner and the provider, ostensibly because it does not exist. At the deposition, petitioner claimed she had a new phone and was unable to pull up records to confirm her increasingly ridiculous tale. Boy, trust me, when she needs a text thread, she provides one. On the undisclosed day of the alleged miscarriage, ambiguously sometime in either September or October, and prior to appearing in court before Judge Gil Ketsis with a fake pregnant stomach and testifying to being 100% pregnant, petitioner claims to have passed 2 fetal sacs. Okay, this is where it gets sad. All right. This is where it gets a little sad. So, here's your content warning. I want to say it gets real, but it actually gets fake. But it gets real in the sense that it's pretty disgusting. Not of course, this sad case of miscarriage, but the lying of that. Okay, so petitioner claims to have passed 2 fetal sacs. She just doesn't remember if it was in September or October. So she can't tell what month she would have had probably what would have been the most traumatic experience of her life, or one of them. JFC Mod says, I'm stressed just reading her lies. I cannot imagine how stressful it must be to tell the lies. Bruce said, this is horrifying. No, it is horrifying. It absolutely is. We knew this was coming. We knew it would come this far, where she probably Googles sad truths of what actually happens with people and all of that, and all that. So, of course, she claims to have passed 2 fetal sacs. Of course, did not go to the hospital, the doctor. And again, the question everyone's asked is, how did she not first of all, go to the hospital or the doctor, but how did she not even remember when this happened? And how did she not know that that was miscarriage? So we keep going. Of course, she claims to have met with telehealth appointment with a provider who she testified was not concerned that she had miscarried. Incredibly, she testified that she had also known the two hand-sized sacs. So she's shown the two hand-sized sacs to her mother and took a photo which she shared with the telehealth provider and her sister. No records have been provided despite repeated requests. Okay, so let's get the mom involved. You don't have a phone, but does your sister? Elizabeth said there's a very special seat in hell for JD. Mrs. Brightside said this is incredibly horrifying for all women everywhere that have ever suffered. Well, if there's anything that can come from this, it's a community of very, very compassionate people. So my only ask of you guys out there, my only plea is do not let her story dim your optimism. Do not let her story cast any doubt into humans being good. And do not let her story make you feel that there's some dark force out there. Most people are not this way. It's almost like a cancer in society. When people, for whatever reason, have disorders or whatever that can cause such incredibly bold lies. I'm getting comments. Sorry. So, yeah, it's heavy. She claims to have met, okay, so she said she took photos, but doesn't know when, doesn't know where they are. There's a fourth man who has, okay, so now we get into the fourth guy. There is a fourth man who has accused petitioner of fabricating a pregnancy, which supports respondents' contention that faking pregnancies is either pathological or the oddest of pastimes. So it supports Clayton's contention that faking pregnancies is either pathological or the oddest of pastimes. I had to read that a couple times there. Petitioner initiated a paternity action out of California in 2014. Wow. A whole decade ago. Or 9 years ago, according to her. You know, she's living in 2023. Boy, if she were living in 2023, maybe don't suck this guy's dick on May 20th. Maybe don't do that. I'm not slut shaming her. Or oral sex is great when it's consensual, but maybe that day doesn't happen. If I could, or you know what, I hate to say it, but maybe this leads to positive change in the future. Let's keep going. Petitioner, just some truth bombs to swallow. Swallow that truth sack. Petitioner has willfully, I didn't even mean sack in the double entendre right there, but boy, sacks indeed. Okay. Petitioner has willfully and wantonly failed to disclose information, so we get back to that part. Now, petitioner had minimal disclosure after evading any compliance for over 8 months. Now, petitioner has testified to attending appointments and speaking with providers who only have access to records that are critical to support the miscarriage she allegedly had in September or October, but did not reveal to respondent or to the court until her motion for confidentiality and preliminary protective order filed January 17th. Respondent has complied with Rule 9C to the extent possible given petitioner's refusal to respond or communicate. As detailed in correspondence, there have been multiple meetings in person. One of the courthouse and at both depositions regarding disclosure, including the court requiring the parties to submit a list of the providers they intend to seek HIPAA records from. So petitioner notably failed to mention Planned Parenthood, Mission Viejo, telemed providers, or others. Petitioner continues to claim there are records in her exhausting attempts to explain away why no medical evidence has supported her fictional pregnancy exists. So she gives them these records. They go, there's nothing in these records. And she goes, there's more records. They say, why didn't you give it to me? Respondent is entitled to his reasonable attorney's fees and costs incurred in this entire action, including filing this motion to compel. Petitioner's commitment to crafting a trail of medical evidence that cannot be verified, an anonymous appointment, a photo of miscarried fetuses that somehow disappeared when you get a new iPhone, a confirmation of an appointment with a doctor she never goes to, is astounding. That petitioner keeps weaving this insane web has only caused respondent to incur more fees to show what he has always known to be true. That petitioner is a fraud. who concocts fictitious pregnancies as a ruse to force men into dating her. Due to the significant efforts he has undertaken, respondent is entitled to his reasonable attorney's fees and costs pursuant to ARS 25324. Wherefore, respondent respectfully requests the court order Jane Doe to obtain the California paternity file from 2014, where she was first accused of faking a pregnancy. Whoa. So they're not allowed to get this file, but they know it exists. So they want the court to ask Jane Doe to order the petitioner, her, to obtain the California paternity file from 2014. Great ask. I'm sure the judge is going to say, you know what? Order it. Order that file. Let's take a look. Let's see what's in the file. I'm curious to see what the truth is here. And I think if you're trying to prove pathology, that you would be very interested in a chain of events that is repeated nature. Order petitioner to obtain the records if they exist from Planned Parenthood, which they don't. Said records should come from the provider in light of the history of doctoring records. So they want the records to come from Mission Viejo, which of course there are none. Dion Shirley said, why don't we know who she is? Hi, Dion. It's for my own benefit. She has sued me in the past for harassment, and I don't like to say her name, but you could find that out in other places. It's just to protect my own channel. You know what I mean? Lindsay Lohan can play her. That's a good idea. Yeah, so anyway, I appreciate the question. But legally, yes, we could say her name. This is all public information. We did have somebody go to the courthouse to pick this up this morning. We have a very robust network of truth seekers out there. So they also want to order petitioner Jane Doe to provide the name of the telehealth doctors who she claims told her that she did, not need to seek actual medical care or hospitalization after alleging delivery to stillbirth fetuses prior to the October and November court hearings. Okay, that's not going to exist. Order petitioner to produce the image, confidential if they exist, of the 2 stillbirth fetuses she allegedly delivered and shared with the telehealth provider and her sister. I would, as messed up as this is, I would hope if this is provided confidentially that enough forensic work is done to confirm that they were hers. I'm grateful that she didn't fake, as far as we know it, images of stillbirths. I'm grateful for that. And yet that's still not out of the realm of possibility. Award respondent Clayton his reasonable attorney's fees and costs incurring in filing this motion to compel. Order such further relief as the court deems just. Respectfully submitted the 11th day of March. So there it is, folks. Now then we have Clayton and Greg, good faith consultation. They sign away their papers. Clayton signs it. And then we have the actual exhibits. So here it is. Dear provider, attached, please find an executive HIPAA release. So here's the exhibit sent from Woodnick Law to Dr. McCool. So we see there the exhibit. Please promptly provide any and all medical records. Of course, they don't exist. Inversely, if your records search confirms no records, please have your custodian of records provide a basic affidavit indicating they are the custodian of medical records. A comprehensive record search was conducted. No records matching. So not finding evidence is evidence at this time. Rachel said, I'm fearful she will use photos of others' losses. I know they exist online. Well, that's when Google searching comes in. You know what I mean? So if she were to do that, it would be heinous. And of course, it would be found out. And I think at this point, she knows that her best case scenario is to have no evidence versus continue to lie. Even though we do know one thing.
She lied?
All right. So comprehensive legal notice of intent to sue. So again, this is the evidence where she intended 2 nights before her deposition. So something like February 28th. She said, I'm going to sue you for $1.368936.8 million. Is meticulously calculated based on the current market value, which again was not true at all. She wanted to sue because he wasn't a good real estate agent, because he was running away from her Pepe Le Pew style. So anyway, that was in evidence because it goes to show that she is trying to get this case dropped. What else is in evidence? Exhibit 3 from Greg Woodnick. It is my understanding that you represent Jane Doe in a paternity claim involving Clayton Echard. Oh, no. Okay, this is new. They redacted it. This is to the legal team that represented who we're calling victim 0, I guess. I would probably need a new name, but this is the victim from 2014. Very interesting stuff. Hold on, let me get a good. So, again, thank you to the 1,400 people in the chat. Please hit the like button. And for further information later today, please do me a solid and subscribe to our podcast, Bachelor Rush Hour. We will have more breaking news information over there as it comes out. We are aware of new information as it's breaking. Okay, so here it is. This is the email from Clayton's attorney to the initial victim 0, 2014. It is my understanding that you represented victim 0 in a paternity claim involving Jane Doe in 2014. That matter involved allegations of a fabricated pregnancy with altered medical records. It is our understanding that the feigned pregnancy was perceived as a ploy for your client to coerce him into a relationship. Since that case resolved in California, 3 additional men have claimed that they were victims of a fake pregnancy ruse by Miss Doe. So we didn't even know that one was actually in the court systems. By the way, victim 0, I believe, is a very high-powered professional. From information I've gathered, he's wealthy in the sense that he's got a high-powered job, and he doesn't want to deal with this. But it doesn't mean it wouldn't be helpful when you look at how tough this might have been on your life. Do the right thing and stop this in its tracks. Miss Jane Doe was deposed on March 1st, 2024, at which time she was asked directly about all prior litigation. She failed to disclose this California matter, but it was during this deposition that we learned of Mr. Victim 0. I think we're going to call him Andrew. Existence, and the fact that he had also alleged she fabricated a pregnancy with him. So in her deposition, this is what's fascinating. She previously said, no, nothing prior. And then when being deposed, she gave up this info. Now you might say, why would she give up this info in a deposition? Well, I'll tell you why. She would only give up this info if she knew he was going to catch her in a lie. But here's what she didn't know. Nobody knew that there was a court case of victim 0, as far as I know. So she regurgitates this info like a bird munching on a worm and spits it out to the baby birds here, dodo bird style. And yes, I believe this is before Mike. Mike was in 2016. This is 2014. Jane Jones says, I've not found these court docs from the searches I've done. That's the point. This document is either sealed or it's just a lot harder to get than in Arizona, which is probably why she wanted future documents sealed. Maybe she got away with sealing this. So she confesses that a guy, now she, I think, claims here, I could be wrong. So she claims it was a real pregnancy. Again, 4th guy. He says he alleges she fabricated it. We are requesting cooperation for access to the California paternity file. With Ms. Doe neglecting to mention the litigation and prior discovery delays in an upcoming trial, we need this process expedited. I'm asking you to connect with Corey Keith to provide production and disclosure of the California court file. Of course, he's not going to be around. Of course, we are not requesting privileged information, only the public file from your court. So apparently it was public, but it's still not available to access. Very strange. Our efforts here are about attaining the otherwise limited access California file without the need to file a motion to compel Ms. Doe compliance with disclosure of prior matters. Arizona rules require that parties attempt to resolve discovery disputes before bringing them to the court. This is that effort, and I certainly understand that your response may simply be that you no longer represent her. I need to ask as a precondition to asking the court for relief. So Greg basically says, I know you're not going to give me the answer, but before I ask the court for it, I have to do this first. Aaron said, how many victims does it take to have a class action lawsuit? It's a good question. Madeline says, do we know if victim 0, Andrew, is a public figure since we know he's powerful with job money like Dave mentioned? No, I don't believe so. And by all means, when I say powerful, I mean he's not and no offense to Sean, the contractor in Arizona, but I believe that this victim would have the resources to keep this like on the DL if he doesn't want it out there. That's when I say high powered, I mean somebody with probably probably doing well for themselves, well enough to not want their coworkers and bosses and people to know about this because it just doesn't look good. Just doesn't look good. Maybe when the documentary comes out, they'll change their mind. Reg says, could she have had a different name for the 2014 guy? Well, while we do know that she has faked her sister's name in the past, I don't believe that to be the case here. I believe she used her real name. So this was the email from Greg to Corey before we find out that Corey actually, was leaving the case. As it has now been a week since we disposed Jane, and we have yet to receive any disclosure. She claims she had an appointment, so this is just the evidence where we want to see the photos, we want all of this, and I'm guessing they didn't hear back. What does this say here? At last, it should go without saying that I'm sure you did not know about the pregnancy fraud case in California. Yeah, of course. So when Corey was present for that deposition, but I'm sure during that deposition realized he was actually in deeper than he thought. Maybe he's a busy guy. Maybe he doesn't go on Reddit. Maybe he only did his basic research. This is February 26th, before the deposition. Corey, I'm confirming receipt of the disclosure received. I'd like to quickly point out that the section with the advisory regarding medical records includes alleged records that are already part of the public domain. My understanding is that not only did she post them, but she also emailed them to various journalists, including Steve Carbone and David Neal. She even referred to some of them in her publications, which she appears to be revising to fit the new alleged miscarriage timeline you presented to Judge Mata last week. I trust she is aware that the original versions have been preserved. I am assuming you are not aware of the extent she has put her records out in the media sphere or her new tactic of revising history. That's right, she did revise history in the sense she changed her timeline from her Medium article in December. Did she not think that thousands of people were watching? Folks, you're getting to watch something play out live that wouldn't have otherwise played out if it wasn't for you. If it wasn't for an audience that really went to all edges of this story and overturned every single rock here in this riverbed of knowledge. Because no way would Nick Law would have the bandwidth to do 99% of this. No way. That's right, he invoked my legal name. How dare you, Greg Woodnick? How dare you, Gregory, invoke my legal name? Get my legal name! Okay, we like Greg. He's done a good job. Gregory, last, I was hoping that your my Screen Actors Guild name is Dave. I actually was trying to catch a flight. David, Neal, and Sasha. I was trying to catch a flight back from Boston, and for the first time ever, they wouldn't let me through the security because the name on my legal name's David, but Dave was on my Amex travel card or whatever. I've never had them stop me when I say Dave instead of David. Colorado Canadian with a $5 super chat says, I optimistically hope JD gets her comeuppance. Did you see KB at DMV? Someone said she was there yesterday too. No, I did not see Caitlin Bristow there. We live in a different part of town. Although on Tuesday I will see her, and you guys will as well. Thank you so much. Margaret says she just overplayed her hand. Absolutely, she did. All right, almost at 1,500 people in the chat. Keep hitting the like button. Let's get to 1,000 likes. It'll really help the channel grow, and we are inching our way to 100,000 subscribers. Bert says, Dave, what if she buys a private photo from some poor woman that can't be reverse searched on Google since it wasn't on the internet? Can they check the metadata? It's honestly a great question. Yes, she could buy a photo. She would have to find a stillbirth photo from somebody that maybe had the metadata dating back to the fall. I mean, yes, you're right. She could do that. I don't think she would, because that would be very hard to do. And then where does she go? Does she go on some website asking people? She'd have to be asking people in real life, which would be super creepy, and you would think she would get exposed for that. So anyway, he says, last I was hoping that your disclosure from Friday would have been something closer to complying with the overdue Rule 49. This puts the financial burden of discovery on Clayton, but is completely not surprising in light of the history here. We will disclose the records we receive in response. So Greg's saying you're making Clayton do all the heavy lifting to get the medical records because you're not sharing them, which is a financial burden, but guess what? You might have to pay the bill. To Woody Law Clerk. Oh, what's this from? Notice of intent to sue. Excuse me, from Greg Woodnick to Woody Law Clerk. Oh, Woody Law Clerk is that's the name of the courthouse, right? Corey, your client emailed me directly tonight. I am sure you did not approve. So this was, of course, from the This is the evidence that was sent where Greg Woodnick received the extortion threat from Jane Doe. This is his way of telling Corey, hey, this is going to be in the, this is going to be in the exhibit. And he also says, I have more witnesses stepping forward regarding your client's pattern of faking pregnancies. Wow. And then sent to Greg. Greg, I'm contacting you directly. So that was from Jane Doe. So we already got that. And we're working our way through it from Greg to Corey. You told judge they had not lied in prior or preceding matters. I trust you have realized that may have been an inaccurate statement in the wake of her deposition. You were copied with the email to Planned Parenthood, I'm sure. So again, all of the information was then sent. So by the way, this is why Corey left. He didn't leave because she threatened extortion, but he left when he realized she lied under oath. Per your client's testimony, please immediately disclose the names of the healthcare providers, the abortion pill provider who allegedly is the only individual who told her she was pregnant with twins and they were a boy and a girl. So again, that being, he said, I was not aware that abortion pill providers were able to use ultrasounds to see the genders at 8 to 9 weeks. I Googled it. Medical science is not aware of it either. Also, I Googled it. Also, per your client's testimony, she was seen in August at Honor Health. They too have no records of her. See attached. Add Jane Doe to the list of, add redacted to the list of victims. I wonder who this is. I'm sure you did not know this because unlike the overt lies plaguing the case, Jane Doe lied to you by omission and never told you about the litigation in California that involved nearly identical allegations. So that's Andrew. Christine says you have so many ultrasounds and proofs of viable pregnancy for each visit. Absolutely. Yep, every 2 weeks. And sometimes every week. Here is our working theory of the case. Let's read Greg's working theory, and maybe we'll read his theory with some X-Files music.
The blood is on your hands, Dave Neal.
Jane Doe is a serial... No, you know what? Maybe we should do this with Law & Order music. I think Law & Order is more apropos. Jane Doe is a serial pregnancy faker and prolific forger of medical documents, apparently for at least the past 10 years. Her modus operandi is to force relationships with men who do not want to be with her. This is Law & Order. Almost done. Exhibit 6. From Corey Keith to Woodnick. Good afternoon. To ensure an exhaustive list, my client asked that I also communicate the following providers for your records. Banner Health, Mom Doc. If these are already covered in your below list of providers, please disregard. Again, that's Corey Keith doing what his client wants. He probably doesn't care or know if they're there. Per the court's request, the providers will be requested records for via HIPAA release signed in court. Of course, she had the wrong court day, but those are the records. Dr. John Jones. Is that the father of Chase J. Jones? Is Dr. John Jones the father of Chase J. Jones? Okay, so anyway, those are all of the places, none of which have responded to any sort of evidence. And that's it, folks. All right, here's what's going to happen. We have 1,500 solid people. I am going live on Patreon right now. Patreon.com/Dave Neal. That's where I will be going live. Let me see if I have a QR code for you guys right now. I don't know if I have one, but I will be there. Let me see. I might have lost the QR code. Join Patreon now for free. Here's where it is. You can join for free, but I will be on the paid version. So, hold on. We just lost it. The free version is still good to join because I do give updates very often, multiple updates a week. But the paid version, I will be going live on right now, which is where we will be making I'll be doing a live stream just like this, but I'm going to be making the podcast for this afternoon. The podcast is free. Go check the podcast out, Bachelor Rush Hour, if you want the free version. If you want to join the Patreon, trust me, the next couple months are going to be pretty wild over there. Mindy says, I think he is now my favorite podcaster. What? Me? Could I be? Thank you. Maybe you weren't even saying me. But that's where we're at. And you guys have a blessed day. Keep sharing love out there. God knows we need more of it. And again, for my Patreon members, I will be live. It's 1:25 Central Time. I will be live at 1:30. I'll be live in 5 minutes. I'm going to go pee-pees. I'm going to go get some nuts. I'm going to not suck on them. I'm going to eat some nuts. And then we will be up. So thank you guys so much. Go to justiceforclayton.com if you want to check out all of the timelines here. Damiana says Dave rocked it out again. Thank you so much. Jen says, join the Patreon, guys. So worth it. Appreciate you all. Again, I'll be live in Patreon at 1:30 Central Standard Time in several minutes. Have a good one, everybody. Hey, last minute super chat from Robin, $2. Thank you so much. I appreciate that. We'll be back on Patreon right after this.